Hi, this is Jennifer Beardsley from Alaska Legal Services Corporation, and I'm here today with Dan Coons, our supervising attorney in our fair housing project. And
Sorry about my tardiness, folks.
we're going to talk today about what to do if your rental needs repairs. First, our today's procession is going to cover the Landlord Tenant Act and what protections it provides, what are essential services, what to do to end a lease early, how to get injunctive relief and damages, what counterclaims are. We'll go through some scenarios of examples of habitability problems, talk about what tenant responsibilities are, and take questions at the end. Feel free to type questions into the chat box as we go along. What is Alaska Legal Services? We were established in 1967 as a private non-profit law firm. We offer free legal services to low-income and disadvantaged people to protect their safety, health, and promote family stability. We practice in consumer law, family law, housing problems, public benefits, healthcare, Alaska Native law, and other specific areas of law relevant to veterans or the elderly. To be eligible, you have to have a civil legal issue. We don't do criminal law. There has to be no conflict, and you have to meet our income and asset requirabilities, and we have to have resources available at that time. You can apply online or by telephone or in person, but you have to apply before we can offer any services. So the Alaska Landlord Tenant Act. Landlords have responsibilities under the act, and a big one is to maintain fit and habitable premises. And that means it has to be a livable unit. They have to maintain in safe and working order the electricity, the plumbing, the sanitation, which includes septic and heating, the kitchen, and the ventilation. They have to provide garbage and waste removal, running water, and reasonable amounts of hot water and heat at all times. And they have to maintain locks and provide you with keys. So what can I do if the landlord is not maintaining my home? Well, it depends. Usually we get calls and people think, well, I'm just going to withhold my rent. This is usually not a good idea and often ends up in eviction. There are some exceptions, but the best options are not withholding your rent because you'll probably end up in eviction court. Wrongful failure to supply heat, water, and other essential services is covered by the Alaska Landlord Tenant Statute. What does that mean? It means your landlord cut off your water, your heat, your hot water, or your sewer service. Or maybe it's just broken and your landlord's not fixing it. Well, the essential services it definitely covers include water, heat, hot water, sanitary facilities, which includes your toilet and sewer, and maybe a few others. And what does the statute allow you to do? First, you have to provide written notice, and it must be in writing of what the problem is. And then you have three options. First, you can fix the problem yourself and deduct the cost from your rent. Or you could have someone else fix it and deduct that cost from your rent. You could demand a reduction of your rent for the loss in value for the period of the problem. You might have to go to court to do that. Or you can get substitute housing and demand that the landlord pay you the reasonable cost above your rent amount. Again, you might have to go to court to do that. Things you need to think about. You can't claim any of these options if it was your fault that you lost the essential service. For example, if you didn't pay the utility, that's your responsibility under the lease to pay. or if you flush something down the toilet you shouldn't have and now it doesn't work. If you don't have the money that you might need to fix the problem or rent a hotel room, this really doesn't help you. And this only applies to essential services. So, for example, even if you had a terrible bed bug infestation, none of this would apply. And it's very important to remember that you have to give this notice in writing. Dan?
All right, so next question is, maybe the problems with your unit are just so bad, or the relationship with your landlord has gotten so bad. Maybe you're just like, I don't want this stuff fixed. I just want to get out of here. Do you have any options to be able to do that? Well, the answer is yes, depending on what exactly the problem is. You can end your lease early without breaking your lease. And that's kind of well, who cares? Who cares if you break your lease? What if I just take off from my unit and say, I don't want to live here anymore. I'm just going to leave. I found a new place. I can afford to move. I'm out of here. Well, the problem is if you break your lease, if you're in the middle of say a year-long lease term or something, you could actually end up owing additional months of rent to your landlord even after you move out. And obviously that's not a situation you want to get yourself into probably. So, because then, who wants to pay for a place you don't even live in anymore, especially if it had a bunch of habitability problems. So that's one reason why you might want to end your lease in this sort of proper way under the law rather than just taking off. I should say there's like some factors that go into what you might end up owing, but we're not going to get into that here. Just know you could end up owing additional money even after you move out if you just break your lease. So what can you do if you want to leave your place and there's habitability problems? There's what under the Landlord-Tenant Act is called a 20-day notice. This is also a written notice. You can kind of find samples of it out there in various kind of landlord-tenant help books and resources. I can't remember for sure, but I think the Attorney General of the state of Alaska, they put out kind of a landlord-tenant guidebook, and I believe it has like kind of sample forms for all the different kinds of notices, and this 20-day notice would be one of them. So you can kind of have something you can build off to send this notice to your landlord. But essentially what it says is this written notice, it tells your landlord, you're not taking care of my unit. This is what's wrong with my unit. You need to fix it, landlord, or if you don't fix it in 10 days, I'm going to terminate my lease in 20 days, right? So I guess one thing you could say about, well, two things you could say about this notice. One, you have to give the opportunity to the landlord to fix the problem. And if the landlord fixes the problem, then you don't have the right to move out. You don't have the right you don't have the right to terminate your lease early. At least the first time around. There's a different rule if the same thing happens within 6 months. But say first time you have this problem, you ask landlord to fix it, landlords to fix it, landlord does fix it within 10 days, then your lease doesn't terminate. But if they don't fix it within the 10 days, your lease terminates in 20 days. So I guess, one of the points is even if you want to move out of a really bad situation, you're kind of stuck there for 20 days dealing with whatever this habitability problem is if you want to properly terminate your lease without kind of breaking the lease. So what are some other things to consider here? In terms of what the problems with your unit need to be in order to take advantage of this lease termination, there has to be a material non-compliance affecting health and safety. So, I mean, it's got to be something pretty serious. So like, for example, if one of your drawers is broken and your landlord refuses to fix it, that's not going to be a basis for you ending your lease. It's not really a material violation. It's not affecting your health and safety. So we're talking about serious things, pest infestations, major leaks or flooding, also lack of heat and things like that. This is sort of an alternative option to that, that lack of essential services that Jennifer was talking about a minute ago. You know, if you want them fixed, those are some of the options you can use. But if you just want to leave, this is a different route you can take if you wanted to leave instead. I've always thought, you know, and I don't know if I've ever actually seen this happen with a tenant, with one of our clients, but I mean, I think it makes sense to say, you know, make sure you really want to move out. Because you're telling the landlord that your lease is going to terminate in 20 days if they don't fix things. And, you know, that 20 days may pass and maybe you couldn't find a new place to live. Maybe you don't have the funds to move and, you know, you are still there after 20 days. You know, landlord might try to go to court and say, hey, the lease terminated after 20 days. I don't think this person should be able to stay here anymore. I don't know. I think it's a risk anyways. So I think it's wise to if you're gonna say my lease is terminating in 20 days, you should be prepared to move. Oh yeah, and I think I briefly referred to this earlier. If the landlord repairs the problem, but basically the same habitability maintenance problem occurs within the same 6 months, you can then terminate the lease in just 10 days and you don't have to give an opportunity for them to fix it. You can kind of just say, hey, you fixed it, but here we are again. We have the same problem. You're not fixing it. I'm out of here in 10 days. And like really, I guess probably with everything we're going to talk about today, if the damage is your fault, then you know that kind of changes everything. You can't take advantage of this if you cause the damage and then are demanding that the landlord fix it or you'll move out. So, all right. Do you have any additional thoughts on that one, Jennifer, before I go to the next one? Oh, you're muted.
No, I think you covered everything.
Okay. Okay.
I think it's important to remember that, you know, 20 days is a short amount of time to move out. So if you are planning to give the notice, you definitely need to be prepared to move.
Yeah, that's a good point. Okay, so what if, so we talked about the essential services kind of notice thing where maybe you can repair and deduct or you can rent a new place. We talked about this 20-day notice that allows you to terminate your lease and move out. But what if you have a serious maintenance problem with a unit and those other ideas don't really work for one reason or another? What other options are there? Because there are all kinds of things that can go wrong. And, you know, another thing related to the 20-day notice and the termination of your tenancy, if you don't have the funds to move into a new place, you know, that's not going to help you, right? So one of the things you can do is sue them, take them to court. There is an option in the Alaska Landlord Tenant Act that allows you to sue your landlord for two different things, for damages, which basically just means for money, right? You know, landlord isn't maintaining your place, and as a result, they should have to pay you because, you know, you basically weren't getting you're not getting what you paid for, right? When you pay a certain amount of rent because you expect to live in a place that has heat and isn't flooding all the time and things like that, right? If you have these problems, that should take away some of the rent that's owed and you should get that money back, right? That's kind of the underlying argument. And secondly, you can sue for what's called injunctive relief, which basically means you're asking the court for an order that your landlord do some specific thing, like actually take an action, like you have a leaking roof, you go to the court and ask for an order that the landlord has to fix that leaking roof, you know, has to hire a contractor and get everything all fixed up so it stops leaking, or the judge gives an order saying you have to go out and hire a professional pest treatment company to, to get rid of the roaches that are in the unit or something like that. So those are two more options. Well, actually, before I go on, a couple things that we should think about as we're talking about filing a lawsuit against your landlord. One, it's a time intensive, that's not the word I'm looking for, but it takes a long time, right? You go sue your landlord, you go to court, you try to get the money from them. It's going to take forever, even if you do end up getting the money. So, courts move pretty slowly. If it's for less, if you're suing your landlord just for money and it's less than $10,000, you can go to small claims court, which is actually much quicker than a typical court procedure, typically, I would say. And it's also a simpler process. It doesn't have a lot of the same sort of complex kind of procedural things that it's really helpful to have a lawyer for. So that's always an option, is going to small claims court. There are risks involved with that too. Basically, it takes a lot of time and effort on your part, but also if you end up losing that case, you could end up owing the other side money for one reason or another. So there's always some risks associated when you file a lawsuit against somebody.
Dan?
And more, another point is that this injunctive relief, you have to file that in superior court, which is going to involve a lot of complex, difficult procedural issues, and it's really hard to do, frankly, without a lawyer. It's not impossible, but it's the kind of thing you want to have the assistance of a lawyer to do, to go to the court and get an order that the landlord has to fix something. So that's something to keep in mind.
Dan, we have a question.
Okay.
If landlord is served with 10/20 day to terminate lease with repairs needed, what is their duty to notice on unit access if repairs are inside the unit?
Well, we'll get to that point, I think, quite quickly. So I will address that. I think it's kind of just a section or two down here.
Sounds good. Thank you.
Anything else that you could think of, Jennifer, kind of related to the sort of lawsuit damages, injunctive relief side of things?
No, I was going to say you have to do injunctive relief in superior court, but you said it.
Yeah. So it's it's doing an injunctive lawsuit is a handful. We have done them at Alaska Legal Services, and let's say from experience, they're a lot of work. But it's the one way you can get an order that a landlord has to fix something. So here's a different kind of situation. It's a situation we often see at legal services, because often people come seek out a lawyer when they're really in a kind of a crisis, and especially if they're getting threatened with eviction. So what if I'm getting evicted because I didn't, or maybe I couldn't pay my rent, but my landlord doesn't take care of my place? There's pests, there's leaks, there's, the heat doesn't work right. And that doesn't seem right that, I, the tenant, can be evicted for not fulfilling my responsibility, which is paying the rent, when the landlord is kind of totally ignoring their responsibility to maintain the place. So is there anything you can do in that kind of situation? And the answer is yes. There's a section of Alaska's Landlord-Tenant Act, Section 190. And what it basically says is that if your landlord, is trying to evict you for non-payment of rent, any claims that you have against your landlord can be used to offset the rent you owe. So in other words, you could lower perhaps to zero, or at least bring down the amount of rent you owe if you can prove that there were these habitability problems, these serious failures in maintenance and things like that. A judge also has an option in this, under this subsection of the law, to do a continuance. So they'll like put off the eviction hearing until the repairs are made and then kind of sort through everything. I've seen a judge do that, I think once, but it's an option under the law. Or the court has the option of saying, you tenant, you should pay rent into the court to hold on to until the repairs are made, and then we'll sort through, who owes who money. So there are a few things. So point being, there are some options that you can bring to the court's attention if you're getting evicted for non-payment of rent and your landlord hasn't been maintaining your place. So the big issue with, excuse me, the big issue with making this kind of argument to the court is like any claims you as a tenant have against your landlord, you got to actually put them in writing, of kind of officially, formally in front of the court in what are called counterclaims. So how you do that is you file an answer. So when your landlord filed to evict you, you get a bunch of paperwork. Part of that is what they call a complaint, and it says why you should be evicted, essentially. And then you're supposed to file within 20 days after that an answer saying, no, I don't owe this, or yes, I do owe this, and how you agree or disagree with what the landlord is saying. And in addition, along with that answer, you can include counterclaims, which are the tenant's claims against the landlord. The court actually has a pretty good form that can be used for that. It's Civ 735. You can find it on the website. Back in the old days when you actually went to court before COVID, a lot of the judges would have like a stack of them in their courtroom, and you could grab one and fill it out. So in order to make this sort of argument about offsetting your rent, you have to have this in writing in front of the court, these counterclaims, formally in front of the court. Like we've kind of said about some of the other options earlier, this isn't going to work for minor maintenance issues, but big things like lack of heat, pest infestations, major leaks, things like that. That's the kind of thing a judge will take seriously and may use to offset some of the rent that's owed. The difficult thing, the challenging thing about this situation, and one of the reasons, as Jennifer said at the beginning, we don't advise people just kind of withhold their rent because the law doesn't really allow it. But even in this sort of weird situation, I mean, what's going to happen is the first opportunity you're going to have to address these maintenance issues and try to convince the judge that your rent should be offset is actually in an eviction possession hearing when you're there in front of the judge. And if the judge doesn't buy it, if the judge thinks, the evidence of the damage isn't significant enough to reduce the rent, then the judge will issue the eviction order right there. I mean, they'll be on the bench in front of you signing it. There's a 2-day stay before they can physically remove you from your apartment. But it means, if your argument isn't successful, you're going to be evicted very quickly after that. So that's always a risk, just to keep in mind when these kind of situations arise. You can, though, typically get a 2-day continuance. Unfortunately, usually only a 2-day continuance for an eviction possession hearing, but that can sometimes be enough time to be able to kind of gather some evidence of the maintenance problems and request a continuance. So if you request that continuance, you got a couple more days to kind of get stuff together, some evidence you could use in order to show the court that, yeah, there is a very serious habitability problem that the landlord hasn't dealt with. Is there anything that you can think of, Jennifer, that might be helpful there?
No, and you can have evidence of photos, other witnesses that have seen what's in your apartment, video, and you can get those things into the court. Right now, it's more difficult due to COVID, but you can get those items into the court through the clerk's office. So it is worth asking for the continuance so you can get that evidence in front of the court.
Yeah, that's a really good point. I mean, I've definitely seen situations where I've sort of been in court, you know, not with the people I'm representing, but, you know, one of the other cases that's going on, and, you know, people will kind of show up and say, this is what's going on, but they won't have like the stuff with them, you know, the evidence, the pictures, the documents, the recording of, you know, the phone call or the texts. And essentially, you know, when you're in front of the judge, that's your chance to show them. You can't just sort of say, hey, there's this stuff out there. So yeah, you want to take that time to get that evidence together and give it to the court so the court actually has it in time for the hearing. Because if it's not there, the judge is just going to move on without it, typically. So here, let's talk briefly about the rules concerning when a landlord can enter your unit, because that's an excellent question that was raised earlier, because there are some specific rules about it. The general rule is that a landlord has to give a 24-hour written notice before entering your unit. And that's not just for repairs, but the landlord could do a variety of things, like do an inspection of your unit. They can maybe show it to prospective renters or buyers, and a few other things. But point being, they've got to give this 24-hour written notice. That's not the case if there's an emergency repair that needs to be done. The landlord can enter your unit without notice in that case if there really is an emergency. The example I always think of, especially up here, obviously, is like a busted pipe, you know, that's frozen or whatever, that's flooding a unit. The landlord doesn't have to just sit around and wait, you know, for the flood to get bigger and bigger and more damage to be caused, and while waiting for 24 hours, right? They can go in and fix that immediately. And there's always, I don't know, I always find this kind of hard to explain, but you can always let in your landlord to make repairs, even if they didn't provide a written notice. If your landlord just shows up and knocks on your door and says, hey, I'm here to fix that thing you asked to fix, you could be like, yeah, sure, and maybe that would be good, but you wouldn't necessarily have to, right? It's by the landlord giving you that 24-hour written notice, it kind of usually creates a situation where you kind of have to let them in. I mean, you can always go back and say, hey, maybe this isn't a good time, can we reschedule or something like that? But basically the 24-hour written notice kind of gives them the right to enter your place to do things. But you can always let your landlord in if you want to. There's nothing, you know, I guess you don't have to fight with the landlord about them coming in if you're okay with them coming in, right? Just because they didn't give you a written notice. On the other hand, the landlord can't abuse the right of access to your apartment, right? They can't be unreasonable. They can't be coming in constantly over and over again for no apparent reason at weird times, things like that. Yeah, they can't do that. It's not really clearly defined. It just says they need to be reasonable. But I think, you know, most people would have a sense of what is or isn't unreasonable. The flip side is you can't deny the landlord access as long as it is reasonable, right? And there are definitely consequences for breaking this rule, going either directions. You know, either side can ask for damages. if they're being denied, if the landlord's being denied access, or if the landlord is abusing their right of access. Either the landlord or the tenant can ask for damages. Either side can ask for injunctive relief, right? An order on behalf of the landlord saying, I need to get in here to do this thing. Judge, order the tenant to let me in. Or the flip side, tenant getting an order from a court saying, no, landlord cannot come in because they're being unreasonable. Or either side could use this abuse of access to the unit as a basis for lease termination. So that's good to know. Anything else, Jennifer, before we move on? I think we're sort of
That
getting
covers it.
okay. I think we're going to talk about some specific scenarios now.
All right. So sample one, or scenario one. My unit is infested with bed bugs. I know this because I've been bitten and I've seen them. I asked my landlord to do something about it, and she said it's my responsibility to deal with it. She even blamed the bed bugs on me. I don't think I should have to pay for this. Isn't it the landlord's responsibility, Dan?
Well, yes, basically, I would say it is, and that's because the Alaska Landlord Tenant Act says that the landlord shall make all repairs and do whatever is necessary to put and keep the premises in a fit and habitable condition. The Landlord Tenant Act doesn't say anything specifically about pest infestation, I think. I don't think so. Instead, it has this broader statement that it's the landlord's responsibility to do these things, keep the premises in a fit and habitable condition. And certainly at legal services, when we look at cases, we interpret it to mean that the landlord is responsible for things like eradicating pests. And I would note that here, this thing, because it's this broad statement, there's not a, with pests, sometimes there's an issue of, is it in one unit, is it in multiple units, is it throughout the whole building? Whose responsibility, whose fault is it, I guess, in part two, I think landlords would typically think if there's a pest problem in one unit, maybe that means, well, that tenant is doing something wrong that's causing the problems. But I mean, that's not really what the state law says. It says it's the landlord's responsibility to maintain fit and habitable condition in the premises. So again, I would argue that this is the landlord's responsibility. There may be some local ordinances that govern pest infestations. I know Anchorage has one, and I wouldn't be surprised if other localities can have them as well. But state law supersedes that. So I think we would argue that it's still the landlord's responsibility. It also might say in the lease that you as the tenant are responsible for the cost of dealing with pest infestations. But again, the state law says it's the landlord's responsibility supersedes the lease agreement. So practically, what would you do, I guess? I start by writing a formal demand letter to your landlord demanding professional treatment of the bed bugs. And I stress that it should be professional treatment. Pest treatment is expensive. And sometimes landlords don't want to pay for that. And they might try to do the treatment of, say, the bed bugs themselves, and that's probably less likely to be successful. For one reason, bed bugs, like roaches, certainly, or mice, or rats, they travel between units. So having a professional who looks at different units and decides, on some kind of treatment plan that's actually going to address the building-wide problem, I mean, that's the proper way to do it, right? Is to not just treat one unit at a time, which becomes like this sort of game of whack-a-mole where the pests maybe are moving from just unit to unit. It sort of has to be a universal treatment of the problem. Typically, I mean, that's typically what pest infestation programs do. I think so. One thing I should add, I guess, to all this. Well, no, never mind. I guess I'll just move on to this third point here, that sometimes the landlord might not believe that there's a pest infestation. I know in the past, I talked to some of the pest treatment companies, and some of them will do like a free inspection of a unit. You know, they'll go in and check and say, oh yeah, there's signs of the bed bugs here, or no, there's not. Maybe you don't have bed bugs, maybe something else is going on. So that's worth a shot.
Clarification.
Yeah.
It sounds like the landlord could have the pest problem professionally handled themselves per the law and then charge me for the service afterwards. Is this something they can do?
Our argument would be no, they shouldn't do that because it's their responsibility. I think there are some maybe minor exceptions. One, I don't remember if I wrote this down specifically, but you know, when a pest company comes to a building to do their treatments, usually what happens is they'll kind of send around like a notice to the people whose units are being treated that says, hey, we're coming in on this day. You know, we're either going to do this like heat treatment thing, which is like basically where they put in a bunch of heaters and jack the heat in your unit way up, and that's supposed to kill the pests, or you know, some kind of poison or whatever. So either way, they're going to say, well, you're going to have to vacate your unit for this amount of time while we're doing the treatment. And they'll also often say you have to do these things to kind of prepare your unit for it, so the treatment will be effective. So I've always, I think one situation where a tenant could be held responsible, you know, financially for the treatment is if maybe they were blowing off those instructions, right? Not following the proper instructions, maybe even going so far as to like not let the pest treatment people in, you know, say, I don't want this right now, go away, or something like that, even after having received proper notice. You know, I think if the tenant is kind of interfering and maybe in some way with the treatment while it's going on, that could potentially be a reason why the tenant could be held responsible financially for the cost of the treatment. That's my thought. I don't know, have you any other thoughts, Jennifer? I mean, partly these are kind of like.
No, but it comes up a lot that the landlord demands tenants pay for bed bug treatment. We don't believe that the landlord can do so, but landlords definitely think they can.
Yeah, it's something that, you know, like I said, you know, it can be in your lease that says that you, the tenant, are responsible for any pest treatments. I mean, you know, we'd argue that's a illegal lease clause, an invalid lease clause, but they're in there, so it clearly reflects that landlords disagree on this issue. So what if your landlord just blows you off, says, whatever, I'm not doing this. You could hire a pest company yourself, then sue your landlord to try to recover the amount of money you spent. Unfortunately, that might only be a temporary fix of the problem because the pests still might be in other units and may eventually return to your units. Like I said, they tend to travel from unit to unit. If you're just taking care of your unit, which is all you can do, you can't make the pest treatment people go into other units, right? You know, it might only be a temporary fix. You could do a 20-day notice, move out, and sue for any damages. And probably a big portion of that damages would be the fact that you'd have to dispose of a bunch of your personal property. Because if you move out, you don't want to carry the infestation into your new unit. You're going to have to treat what you can and throw away what you can't, right? Furniture, for example, it's like, what can you necessarily do about the furniture yourself? You know, you might be able to do things with clothes and bedding in terms of, you know, there's things about drying at a certain temperature for a certain amount of time can kill the bed bugs. But, you know, what can you do about a couch? And you don't want to bring a bed bug infested couch or a roach infested couch to your new unit. So that's an option, but it obviously ain't the greatest option. Finally, you can file a lawsuit against the landlord requesting an injunction that the landlord professionally treat the infestation. And this is something we've done a few times at Legal Services, essentially successfully, I would say. And but as I mentioned, this injunctive lawsuit is a complex litigation in superior court, and it's the kind of thing you probably need a lawyer for in order to do it successfully. Any other thoughts before we leave pests behind? Talk about something else. Okay. So another scenario. What if my landlord cuts off my heat? My lease says that it's the landlord's responsibility to pay the heat, but he just called up the gas company and shut it off. You know, maybe he's mad at me for this, that, or the other. Who knows why? It's winter. I went out and bought a space heater, but it's still not enough. I mean, it's still, you know, like 50 degrees or whatever in my house, even with that space heater, even in the room where I have the space heater. And I'm the one who has to pay the electric bill, which is now going to be huge because now it's a space heater rather than your gas stove. And yeah, so it's a real problem. What can you do?
Well, we talked about essential services, which gives you the opportunity. The landlord has to provide essential services, and heat is definitely one of them. So you can do the three things we talked about, which is procure it yourself. Now, that might be difficult with the utility company. You'd have to get the utility in your own name. And that may or may not be possible. You could definitely recover damages based on the lack of value in the unit. And you could definitely procure or get other housing, such as a hotel. But you need to make these requests in writing. So you definitely want to let your landlord know immediately in writing what the problem is. So you'd send out the notice regarding the failure to supply essential services, or you send out a 20-day notice and move out if the problem isn't fixed. You can still sue to get the compensation for the higher electric bills. And you can do that in small claims court, most likely. The other option is to file for an injunction. But again, that takes time and it has to be done in superior court, and it's not the easiest process to do on your own. No heat is a problem in Alaska in the winter. It's a problem in Alaska in the summer sometimes. You might want to call legal services immediately if you don't have heat. Because sometimes a call from a lawyer can make the process go more quickly.
Yeah, and I mean, I think this is a tough situation sometimes because if you don't have the money, I mean, so just the way the scenario is set up, right? It's like normally it would be the landlord's responsibility to provide the heat and pay for it by paying the gas company, right? And now all of a sudden there's this new expense put on you. Maybe you don't have the money to pay for, I mean, as Jennifer said, sometimes it's like working with the gas company can be difficult. Getting it put in your name maybe can be a challenge in itself. And also a thing we see a lot is like when people try to get it put in their name, they have like some back bill to the utility company. And then the utility company is like, well, you owe us $1,000 from like 5 years ago, and we're not going to let you like set up a new account unless you pay off the $1,000 you already owe us. So, that can, so point being, this whole notice for essential services, it's like if you don't have money to do these things on your own, like get the thing fixed or set up in your name, or to go out and rent a hotel for a few days, this doesn't really help you, right? Which stinks.
Exactly.
Yeah. And same with the 20-day notice and moving out. It's like if you don't have the funds to move to a new place, that's not real helpful. So really the injunction in some ways is the only thing that can help, but it's also the most kind of difficult thing to do. And Jennifer made a good point. It's like you can get relief from the court pretty quickly, but not instantly. It still takes some time. And that's time you're maybe sitting in your home cold. So I guess another thing I'd bring up, and I've never really done it much, maybe at all directly, but I think sometimes there are things that can kind of be finagled, if that's the right word, with like the utility companies, like kind of, sometimes there's things to be done there too by like sort of some kind of less obvious options with the utility companies themselves. And that's something that legal services can potentially do. I know some of my colleagues have done things like that in the past, where they've kind of found a way to get past the utility company stonewalling and get things going again. Like a reasonable accommodation. I guess that's one of my thoughts, that is still a potential thing, is asking a utility company for a reasonable accommodation under the Fair Housing Act if you have disabilities maybe that are related to the utility shut off.
All right.
Next one.
Yes.
We'll cover that one. Okay.
So my rental unit included a washing machine and dryer. It's one of the reasons I rented the place. I was willing to pay higher monthly rent because of it. The washing machine stopped working and I asked my landlord to fix it, but he refused. I now have to spend a ton of time and money at the laundromat because I have a large family. I'm not going to drag home a bunch of wet clothes, so I have to dry at the laundromat too. I just want to get out of this lease. Is there anything I can do?
Well, I mean, if you want to get out of your lease, what's the first thought? One of those 20-day notices terminating your tenancy. But that's kind of the tough thing. It's I guess maybe I would say it's kind of risky. I don't know. What the statute really specifically says, and I kind of glossed over this when I was originally talking about the 20-day notice, is that it's a material, you can give the notice if it's a material violation of your lease or a material violation affecting health and safety of Section 100 of the Landlord Tenant Act, which is that one that talks about keeping your place in a fit and habitable condition, and those other landlord responsibilities that we talked about at the very beginning. So, I mean, maybe the lack of the washer and dryer is a material violation of your lease. I mean, that's part of what you're paying for. I don't know, but it seems kind of risky too. I mean, I think your landlord could turn around and say, this isn't good enough. I'm going to sue you for breaking your lease because you moved out early and you didn't have a good reason to. Honestly, I don't know. I don't know if you have.
It's a risky one too. I think for the individual, having a washer dryer is important.
Yeah.
I know mine is. But I think it would be sort of risky to say it's a material violation of the lease. But are suffering damages because of it.
Yeah, certainly. I mean, a safer thing to do, though, again, it doesn't fix your problem necessarily much in the short term, is to sue for damages. In probably small claims court, again, it would probably be less than $10,000 worth of damages. I would expect. Yeah, so that's yeah, not very satisfying, I suppose, answer to this question. It's a kind of situation maybe where if someone came to legal services, we would write a letter on their behalf and try to kind of see if we can just get the landlord to come around. But yeah, that's, I don't know. I'm out of ideas on that one, to say the least.
All right.
I mean, I don't think you do an injunction to just get your. I mean, it's just too much work, kind of to do. I think you theoretically could, but. Okay, I guess I read this one. So I just received an eviction notice for non-payment of rent. It gives me 7 days to pay all the rent I owe. That's the typical time in a notice for non-payment of rent. I don't have the money. I can't pay the full amount, and the landlord won't take a partial amount. But my landlord has never responded to multiple requests I made about a roach infestation in my unit and a place in my roof that leaks so much it will fill up a 5-gallon bucket in one day during warm periods of the winter and break up. I know it's my responsibility to pay the rent, but it just doesn't seem right that the landlord is ignoring her responsibilities and I'm the one who gets evicted. Is there anything I can do to stop the eviction and get this stuff fixed?
Well, the best thing you can do is raise the defense in court. You can file an answer in the eviction case that raises the counterclaims. We talked about this. You have to file that civil 735 form or something similar. And you raise the counterclaims against the landlord for failing to maintain the unit and try to offset the rent that you owe. You have to find out if you originally notified the landlord in writing about the problems at your place. If not, it's okay. You just need to prove to the court that the landlord knew about the problems. So, for example, if the landlord had been over at your place and saw the 5-gallon bucket and with the water flowing into it, you don't really have to say that you notified him in writing because he saw it. But if the landlord didn't know about it because they never came to your place and you never told them about it, you're not going to be able to have a good counterclaim. And then you want to have evidence, and that's what we talked about: pictures, videos, witnesses. And you want to get that evidence in front of the court. It's not good enough to just say, I have pictures on my phone. You want to make sure that the evidence gets in front of the judge. Print out the photos, and if you can. It's always risky to try to offset rent. It's up to the judge to decide how much is offset, and it's rarely the full amount of your rent. Some judges think you got a roof over your head. Well, most of your rent is due. It just depends, but that's the best way to handle it.
Yeah, and God, what was I going to say? I just spaced it. I had a very profound thought to add, but it's flew out of my head. But I saw something kind of popped up in the chat, and someone was asking about a specific part of the statute relating to landlord's responsibility to maintain appliances, and that's correct. That's under Section 100 of the Landlord Tenant Act. So I think absolutely the landlord needs to fix it, is responsible for fixing it. It's part of, it's the same thing as if your refrigerator broke down, due to no fault of your own. They would have to, that's part of what you're renting, right? Is a place with appliances that you're going to use, and that's what you're paying for. But the flip side is, the question is, what can you do practically about the fact that your landlord has violated the law? So I think that's where it gets a little more difficult, and maybe the options aren't quite so great. And I think that's frankly something you see in the Landlord Tenant Act. You see some laws that are parts of the statute that are very protective of tenants, but then enforcing those rights can be challenging. Like it's not related to this habitability issues that we're talking about today, but like when the person gets locked out, that's clearly illegal. If a landlord just locks out a tenant, but kind of what you can do about that efficiently and quickly is challenging. Sometimes, depending on the exact situation. And I remember what I was going to kind of say to jump back to this thing about the eviction defense issue is that one, even if the judge doesn't completely zero out your rent responsibility, if the rent amount owed is lower, I'd argue that the judge would require the landlord to issue a new notice for that smaller amount. So that would buy a bit more time, and maybe you can afford that smaller amount. I mean, in other cases, I remember the tenant showing up with the money she did have like in court, and when the judge like lowered the amount of rent that was owed, she like paid it to the landlord right there in court. And then she didn't get evicted. So that can kind of work out in different kinds of ways when the judge lowers the rent amount. All right, well, we got like 4 or 5 minutes left. I don't know, was I going to talk about this? That's fine, I will. Just to add, tenants have some responsibilities too. It's not just all the landlord's got to do this, that, and the other. It's a tenant's responsibility to dispose of garbage and other waste in a clean and safe manner. The landlord has to provide the sort of stuff for throwing stuff away, but the tenant has to actually bring it out there and throw it in the right place. You got to use everything, the electrical, plumbing, sanitary, heating, air conditioning, the kitchen in a reasonable manner. Can't deliberately destroy or damage premises. Can't unreasonably disturb neighbors. You got to pay your rents. Again, in relation to everything we've kind of said here. And to give required notices in writing if there are damages, if you're requesting repairs or planning to move out early, terminate your lease early. There are some further good resources out there that Alaska Legal Services have. We have a website called AlaskaLawHelp.org. It's got sections on various different civil law issues, including a large section on landlord-tenant issues, the kind of stuff we've talked about today, but also all kinds of other landlord-tenant issues. It's recently had a lot of stuff related to COVID, eviction moratorium that's now ended, but it's should be kept up with good current information about various housing issues as well as other civil legal issues. We also have a landlord-tenant hotline that is staffed by some excellent and much appreciated private attorneys who volunteer their time on Monday through Thursday from 6 to 8 p.m. Phone number 1-855-743-1001. And they can provide information about landlord-tenant issues. One thing I thought of that we should have done at the beginning, but we didn't, is just kind of say, all this information we've given is just that, it's information. It's kind of not advice as to a specific situation. So, I think this kind of helps inform people of their rights, and that's what it's meant to do. But I wouldn't sort of take anything, any specific, little change in facts in your own specific situation might change what you need to do in an eviction situation, or a situation where you're facing maintenance problems. So it's always good to reach out to a lawyer regarding your sort of specific situation.
And I don't know, Jennifer, if there's anything else you'd like to add before we finish. And there's also, if anyone has any more questions, feel free to.
No, I think that's good, Dan.
Okay. Ambria, any last minute questions for us?
No, there has not been any other questions added. We have posted the Alaska Law Help and the Landlord Tenant hotline links for information.
Yeah, certainly feel free to reach out to Alaska Legal Services or to the Landlord Tenant Helpline if you do have any further questions. Well, thanks for your time.
Thank you.
Bye.